a client was accused of an offense. His son was called in as a witness, but we were apprehensive that a lot of times what happens is that the police will call you in as a witness, interrogate you, and in fact nothing happens. But the report will be that we called him in as a witness, we wanted to interrogate him, he was not complying, he was not assisting us with the investigation, and it seems that he is also an accused person. So we are placing him under arrest. And that's a great way for the police to call a person to the police station and then arrest him on the spot and then produce him before the court. Now
this is arrest of witness, not a co-accused.
So you're called in as a witness, but then you are arrested as a co-accused. These are things that also happen as well.
And if you do not comply obviously with the investigation, then as a witness also you can be arrested. But this is a trick the police spins around
and
here.
as a matter of practice, you can safely assume that if you are being called in as a witness and if there is any allegation against you in the complaint filed by the victim, then you are going to be arrested. You have to assume it. Because if you say that, all right, I'm going to see and I'm going to give it a shot, from what I have seen, there's a very high likelihood that you actually will be arrested. So what is the solution to that? Even if you're called in as a witness, you go and apply for anticipatory bail from a sessions court. When you go to the sessions court, you file for anticipatory bail, the police will come in and say, we do not consider him an accused person. We have just called him for interrogation. How do we make up our mind whether we want to arrest him or not? To that, for a very long time, lawyers used to say, all right, then this petition may be treated as dismissed as withdrawn. However, the state may be directed that if they have an intention to arrest me, then at least a 2-day or a 4-day or a 7-day notice period may be given. So if the police would now it is at least the onus on the police to actually give a notice in writing before arresting the person, even if he goes to the police station.
This was a prayer in what petition? This is not the anticipatory bail thing, no?
This is anticipatory bail
this
itself.
Interim bail or something like that.
No, this is anticipatory bail itself. And a lot of times what happens in these anticipatory bail cases is that the police will come and say, we do not want to arrest the person. We do not want to arrest the person right now. We just want to question him. So why are you seeking anticipatory bail? But the problem is, the moment you actually reach, the only thing that the police are going to do is write on a piece of paper, the witness is not cooperating, therefore we have to, we require custodial interrogation. That is why we are placing the person under arrest. And how things usually go, there is no interrogation, there is no nothing. The police will only write their statements and call it a disclosure statement. They'll arrest you, they will write your so-called disclosure statement and then say that yes, we have conducted an investigation, this is what has happened. This is what almost entirely always happens. So it is always better to go and seek anticipatory bail. However, a little barrier that has now come up is very recently the Supreme Court has again woken up and said, no, in these kind of situations, the court can either grant anticipatory bail or reject it. The court cannot say that, all right, anticipatory bail application is dismissed as withdrawn or dismissed. However, because the police says that they do not want to arrest, and if the police want to arrest, they can give a 7-day notice period. Supreme Court recently, very recently in a judgment said this. This has been held time and again, and I think every 3 or 4 years, the Supreme Court reiterates this principle, but
that make your anticipatory bail orders black and white.
Yes, it's either this or that, you cannot have something in the middle.